what I'm here to talk to you today about is your right to representation if you come under investigation at your job, and the just cause standard. Now, what this means is that your employer cannot discipline you or terminate you or interfere with your job by the form of adverse action without just cause. That means they have to have good cause or just cause to take that action. And they have to prove that. It's important for you to remember that the burden of proof is on your employer. You don't have to prove that you're innocent. You don't have to prove that you didn't do something. Your employer has to prove that you committed misconduct, and that misconduct justifies whatever level of discipline they intend to propose under the circumstances. Now you might ask, where does this just cause standard come from? Well, it depends on what type of employee you are, but for the most part it comes from either state law or federal law if you're a federal employee, or from your collective bargaining agreement, otherwise known as your MOU. For example, if you are a firefighter or a police officer, there's specific statutory provisions of the government code that apply to you, called the Peace Officers Procedural Bill of Rights Act or the Firefighters Bill of Rights Act. In most cases, it's going to be under your collective bargaining agreement where you have bargained, or your association has bargained, probably many, many years ago or decades ago, that you cannot be disciplined but for a showing of good cause or just cause. Now, before an employer can discipline an employee, the employer has to do an investigation. It has to be a fair, comprehensive, and complete investigation. And an essential component of that investigation is the interview of the employee, sometimes referred to as the interrogation. As the employee, you have a right to tell your side of the story. Here's a super important rule you need to remember. You have a right to a representative before you go through your administrative interview or interrogation. Now, your employer has to advise you that you're under investigation and that could lead to adverse action, but the burden falls on you and you alone to request a representative. Your employer doesn't have to tell you you're entitled to a representative. Your employer doesn't have to get you a representative. You have to make that request. But once you make that request, you raise your hand and say, I want to have a representative. You're entitled to that representative, and that person should sit in with you during your interview. So then the question is, what does that mean, a right to a representative? Who should be my representative? Well, if you're represented by our office, which hopefully you are, or you will be soon, you should be and will be represented by one of our lawyers or one of our labor specialists. That's who should represent you. Now, you could have maybe one of your association board members or a union shop steward represent you, even your coworker. That's usually not as good because you don't have the attorney-client privilege that protects the confidentiality, and you might turn that coworker of yours into a witness. So it's important that you understand you have a right to a representative, and absolutely you should exercise that right. And the representative should be an expert, one of our people, for example, in this field that can take care of you. So now the time has come for your administrative interview. And I could talk all day about how you get ready to go through these and how you do them right. There's just a few basic rules you should understand, and your representative is going to take care of most of this. First of all, you need to be prepared. Gain as much of an understanding as possible of what the allegations are against you as you possibly can. Go into the interview confident and prepared. Then, in the course of the interview, the biggest piece of advice I could give you is be honest. Be concise, be direct, answer the question, but be honest. Do not exaggerate, do not embellish, and above all, do not lie. That will end your career, in all likelihood. So, remember those rules and you should be fine. One last comment on your administrative interview. Keep in mind why you're there. You're there to give your side of the story on a particular set of allegations, about an incident possibly. You're not there to tell your life story. You're not there to get a promotion and tell everybody how cool you are and how great you are and how many years you've worked there or how hard things are at home or digress off into your family law problems or whatever it is. You're there to answer their questions specifically and defeat the allegations. So stay focused as to why you're there. Again, your representative will help you with this, and this is part of the representative's job to make sure you stay on track. Now, after your employer finishes its investigation, the employer may decide that it's going to take some form of disciplinary action against you. It might be minor in nature, it might be moderate, or they may try to end your career. They may try to terminate you. You should know you have the right to an administrative hearing or appeal. And you absolutely, in almost every case, should exercise that right. That means you're entitled to an evidentiary hearing, not just a little sit down with your department head, not a meeting with the city manager or the county executive. You're entitled to an evidentiary hearing. These are usually described in your collective bargaining agreement, where there's an arbitration procedure. If you're a state employee, you follow the state personnel rules, but it's a comprehensive administrative process where you get an evidentiary hearing before an administrative law judge or an arbitrator who hears evidence. And there is, at this hearing is where the employer has the burden of proving that you committed the misconduct that they allege. In other words, you committed the specific facts they allege, and that the penalty they're imposing on you is appropriate under the circumstances. Now, how you do the hearing, or how your representative does the hearing rather, is very important. And we have a very good track record and great luck at winning at these administrative hearings because we follow basically a trial principle that all our trial lawyers follow. There's some important points and factors I want you to keep in mind. The arbitrator or the administrative law judge consider a whole array of things about your case as to whether the discipline should be upheld, whether it should be modified or overturned entirely. First of all, the arbitrator will consider, did you know the rule? Did you know of the rule that you're accused of violating? Did you know the rule even existed? That's important, that you knew the rule was there. You can't be accused of misconduct, let alone discipline, for violation of a rule you didn't even know existed. Second part of that is, assuming you knew the rule was there and existed, is the rule fair? Is it reasonable? Or is it outrageous? Most employers' rules and regulations are perfectly reasonable and well tried and true on a well-worn path. Most people get that, but once in a while they'll pull out a rule that's totally outrageous and ridiculous and unreasonable. That's something an administrative law judge will look at. There's a whole bunch of other factors the arbitrator will consider. Some of the important ones are, did the employer act in a timely manner on the allegations of your misconduct? Or did they sit on it for months? Or we've had cases where they sit on it for years. The employer has to act promptly, especially in cases of serious disciplinary action. Then, and the biggest place we score points in these hearings is, did the employer do a fair and comprehensive investigation? That requires that you go through that investigation with a fine-tooth comb, but many, many times you can find out that the employer didn't do a fair investigation. They didn't do an objective investigation. In fact, if you can show from the start they were trying to prove that you did the allegations, you're going to win that case, or you should win the case. The employer, if they're smart, what they'll do is do a fair, comprehensive investigation where they just try to get to the bottom of the case. They just want the facts, ma'am, just like in Dragnet. Another super important factor to keep in mind is, at the hearing, keep track of whether the employer is proving up the allegations against you. They have to bring evidence in, and they have to prove that evidence up, whether it's through witnesses or documents or other evidence that you committed the misconduct. Are they doing that? They can't just have a department head come in and vaguely talk about how you're a piece of garbage and need to be fired. No, they have to prove this case up, piece by piece by piece of evidence. And many times the employer can't do that. Hold them to their burden of proof. The last thing you need to think about carefully is the penalty appropriate under the circumstances? This applies in serious disciplinary cases or termination cases. And that's something the arbitrator will consider, and oftentimes an argument that will get the employee back to work. Is the termination, for example, appropriate under the circumstances, based on the allegations, the quality of the evidence, and also the history of the employee? Does the history have 25 years of super high quality service with no prior level of discipline, on the one hand? On the other hand, has the employee only been around for 5 or 6 years, has it been on the verge of termination the whole time? Those are important factors to consider. And an arbitrator will often reinstate an employee because the penalty of termination just isn't appropriate. The arbitrator might uphold some level of discipline, but not terminate the employee. The last thing I would say in this series, and I could talk about this all day, and I urge you to call me if you have other questions, but the last thing I'm going to talk about is whether you should resign. That offer will come up many, many times in the course of the investigation, where the employer might come to you and say, look, let me do you a favor, my son, and why don't you just resign? Well, 9.9 times out of 10, that resignation works to the employer's benefit and not the employee's benefit. There are times where a resignation is appropriate, and there are circumstances where it can work to the employee's advantage. And that's usually when there's criminal charges pending, or the potential of criminal charges, or a few other factors. But before you resign, you need to sit down and carefully work out whether it's a good idea with your representative. And you need to go through it very thoroughly and make a very well-informed, thought-out decision. Never resign on the spur of the moment. Never resign when you're under stress. Because remember this, once you resign, the minute you submit that letter of resignation, or if it's a verbal resignation, the minute you utter those words and your employer accepts that resignation, it's a done deal. The law is crystal clear on this. We can't go back and undo it. So if you get mad, you resign, and 5 minutes later you come back in and say, I just got mad, I want to take it back, your employer doesn't have to do that. They can say, you're out of luck and you're gone. You resign. Well, remember too, you resign, there's other implications that affect your job or your income. You won't get unemployment benefits. Your workers' comp claims will be affected if you have those pending. Other things, vacation buyouts, sick leave, those kind of things could be impacted. All the collective bargaining fringe benefits may be affected. You need to think it through. My advice to you is, in most cases, you're never going to want to resign. You want to stay in the game and keep fighting. In the rare case where it's going to work to your advantage, you need to work it through very thoroughly with your representative. So thanks a lot for listening to me today. This is just really the tip of the iceberg on this area. This is stuff we do all the time. Please give us a call if we can help you in any way. Thanks.